What this case was about was a need to change banking practices on a going forward basis. What specifically was happening with minorities, and particularly with African Americans, is that an African American during this time period was likely to pay 200 more basis points for the same loan than his or her white counterpart. So when a black person in America bought a loan and they were paying more, that's institutional discrimination. The NAACP was very concerned in 2006 with loans that were being sold to blacks in America. And by early 2007, they had approached us and they asked us to investigate whether or not to file a lawsuit. When we started initially filing these lawsuits, we were approached by the various banks and lending institutions, and they all said virtually the same thing. We know that this is going on, but it's not us. So the NAACP wanted a role that would allow them to have some oversight into the banking and lending practices in America. The first case we settled with Wells Fargo, which really stepped up. They wanted to be the first to enter into an agreement. They entered into agreement in the first part of 2010. And since then, and even today, we've negotiated agreements with Chase, Citi, and we're working on HSBC, GMAC, Bank of America, and other institutions that we're trying to work with to effectuate the same kind of change. On a very personal level, I think it's every lawyer's fondest dream to represent an organization like the NAACP because they represent really what's best about America and about what we can do as a society when we all work together.